Conversations with Azu Ishekwele.
Except for ward and local government elections, every election in Nigeria doesn't end with the collation of results or an announcement of same. Electoral conclusions end in the courts and go all the way to the Supreme Court. Why is this so? This forms the basis of our discussion today on deepening the conversation, our interactive segment of Conversation with Azu, a weekly dialogue on life and politics. Azu, the award-winning columnist, is with me in the studio to discuss why he has written about, to discuss his reflections on the Supreme Court judgment in election matters recently decided. You're welcome to the studio, Azu.
Thanks for having me, Julius. It's a pleasure to be here.
So let me start by asking how we can buck this trend of not accepting electoral defeat, electoral defeat until the courts make a pronouncement.
Well, that is a very broad question because the different parties obviously would have a role to play in ultimately allowing the voters' will to prevail. I think it's also a reflection of the desperation for power. It's not just a competition. It's become so intense and so desperate among politicians that politicians hardly accept a loss, even when it's obvious that they have lost. But I think to answer your question more directly, I think that there is a role for the arbiter of elections to play. That is to ensure that we have rules that generally also are clear enough and implementable to ensure free and fair elections, sufficiently transparent, and also enforced also security agencies. And so when elections, you can't have perfect elections, but when on the whole the perception is that the elections have not been rigged and has been conducted fairly and transparently, the chances for dispute after the elections tend to be limited. Of course, but parties also, especially politicians, have to be more sportsman-like or sports-like in their attitude to politics to ensure that it's not a do or die affair. But I think that what has worsened that trend of desperation in politics has also been the concentration of focus as politics as a means to an end, whatever happens. The situation also in the past in this country. I'm not saying everything about the current situation is bad. I don't believe that. But the situation in the past also, when the electoral law made sure that all election disputes were settled before people were sworn into positions, helped a bit to deal with that sort of bitter contestation after elections. And also there was also before now in the Electoral Act a situation that allowed elections by vote at the National Assembly level to end at the Court of Appeal, and also those of governors to end at the Court of Appeal. It was only presidential elections that went to the Supreme Court. So perhaps we need to look again at legislations. I'm sure that people will say, how will there ever be an end to it? But I think to summarize, it's a function of legislation, but fundamentally also a function of attitude by politicians to politics.
I omitted in the introduction of mentioning the title of the column, which is The Road to Thanksgiving. Comically titled, The Road to Thanksgiving is the title of Azu's column, which we are discussing today. Azu made a strong case that for election petitions to be decided, that election petitions should actually be decided before swearing in of winners. Don't you think this is likely to create a vacuum?
No, it's not something.
Vacuum.
I do not think so. It's not something we have not had before. And of course, I've shown in my column the example there are many examples going all the way back. But I mean, at least in the last 40 years, we can easily remember the example of what happened in Oyo State when Bala, after his first term, 1983, he won the election first time. He was going for his second term, but he thought he had been unfairly rigged out by FEDECO. by federal forces using under NPN. So he went to court, he contested that, and of course the court he lost on appeal. But you also remember that in the 1979 election, the verdict at the Supreme Court was decided 3 days before swearing in. So it's not a strange or an unusual practice. It's something that has happened before, and it's also the prevalent practice in other jurisdictions. In Kenya, for example, where there's a constitutional court, that is the practice. Because once a man ascends the Mount Kilimanjaro of power, to bring him down from that Olympus to be competing with it just gives him an unfair advantage over people who are in dispute with him.
And a lot of our listeners probably want to know this fact you're stating, that has been the situation before. How did we lost it? How did we get back on it?
Again, that I think is a function of lawmakers, okay? Because you cannot change the law except either through judgments of the court or through decisions by lawmakers in a democratic society. So politicians obviously always are trying to look for what they think gives them
an advantage.
But when they try to when they think they have solved one problem, they end up creating just creating another one. So I think it's also a function of the legislative. It's something that the lawmakers themselves have to take a decision and then decide what to do about it. But the law has to be looked at again.
Something struck me as I read your column. The cases decided last Friday, for example, tended to be a retention of the status quo. Do you think the Supreme Court might wittingly or otherwise be trying to, reduce the cycle of off-cycle elections we have?
I do not know what the intendment, as lawyers say, whatever that means, of the Supreme Court was in taking that decision, or what the common English speakers like us will say what the intention of the Supreme Court was. But obviously, Supreme court decisions had overturned several elections leading to off-cycle elections. And for the first time in many years, this is the first time when we are going to have this number of disputes, all of them settled in favor of the sitting governors. Usually from time to time, you have a situation where there really is an upset, but we haven't had that in this particular case. I do not know what the intention of the Supreme Court was, but the Supreme Court, obviously, the ruling and the judgment of the court is one that has created concern, justifiably so it might be in many circles, because the Supreme Court severely criticized the judgments of the lower courts, especially the Court of Appeal. But the Court of Appeal relied on the judgments of the Supreme Court in reaching its decision. That's what I find quite interesting. And I am told that in the last 2 election cycles, just about 5% of the decisions of the Court of Appeal have been overturned in 2 election cycles. So your guess is as good as mine what may have happened. Maybe those who spent 7 nights and 7 days and 7 days and 7 nights praying sort of prevailed at the end of the day.
Mohammed or Bauchi.
Really, I really don't know what the intention was. What is obvious from that judgment, even though there's been a suggestion that it's also meant to create stability. But that has also raised serious questions about consistency and reliability of our jurisprudence, especially as they have to do with elections.
And that perhaps paved the road to Thanksgiving.
Yes. That prepared. They have obviously prepared the road to Thanksgiving by this set of judgments.
There are practical cases. You mentioned inconsistency. There was this case in Zamfara in 2019.
Yes.
There's the case of the former Senate President Ahmed Lawan.
Yes.
There's all of them were pre-election.
They were pre-election internal affairs of the parties. Correct.
This is the Supreme Court. In other words, is setting a bad precedent.
Well, I mean, your guess is as good as mine. I mean, in the cases you have cited, the Supreme Court decided that it was not the business of the court to look at, and including, of course, the case of the so-called double nomination of Vice President, Kashim Shettima. The Supreme Court decided that it was not the business of the court to look into the internal affairs of the parties, except where a fundamental constitutional breach had occurred. So if you go back, Amechi, it goes back to the time of Amechi. That was that 2000. Yes, exactly. That was at 1999 or 2003, thereabouts. I can't remember the exact year it was. When the Supreme Court laid that precedent or took that decision that it was solely the business of the party to decide which candidate it wants to field, and it's not the business of the country.
2007, I think it was Peter Odili who was the governor of Rivers
now the Supreme Court has literally gone full cycle, and your guess is as good as mine what the lower courts, what kind of precedent lower courts will now have to rely on in matters like this. I really do not envy them.
I think this is a place where we just need to stop these conversations where Azu and myself are not legal professionals, but we must do our way in paving the route.
So we are pocket lawyers.
Conversations with Azu is published on the back page of Leadership and syndicated in more online platforms that we care to mention here, syndicated across Africa and outside of the continent. Please visit our site at azuishekwene.com and subscribe, share, and view our content. Thank you very much for coming. Thanks for coming.
Thanks for having me, Julius.
Yeah.
Conversations with Azu Ishekwene.